Hello, everyone, and welcome to the latest episode of Xbox 2+1. I believe this is episode 23. We've done 23 of these now, Ryan. Pretty awesome. And
we should do more of them, actually.
Yeah, we should. But it can be hard to line up everyone's time zones and schedules and all that kind of stuff. So we massively appreciate everyone who takes the time to come and join us. And this week we have an illustrious guest who's been on the show before to talk to us about all sorts of gaming legal things. It's Florian Mueller. Hello there, mate. How's it going?
Yeah, hi. Thanks for having me again for a second time. Last time it was all about Activision Blizzard, and today that's only going to be our secondary topic.
Yes, indeed. I mean, obviously the big legal topic of the now is Palworld versus Nintendo. Florian, can you tell us a little bit about yourself? I mean, most of our long-time listeners know exactly who you are, but for those of us who are new to those who are new to the community, can you let us know a little bit about yourself and where people can find you on the internet?
Sure, happy to do that. So I just focus on the parts that are relevant here, which is games and this patent law and antitrust type of stuff, right? And
Yeah.
I worked with Blizzard. I was, in fact, the first person outside the US to work very closely, like as effectively a full-time person with Blizzard in the mid-1990s, and launched Warcraft 2, Tides of Darkness in the Central European markets. And that was actually the first place where Blizzard became #1 in the sell-through ranking. It happened in the US too, but a few months later. And then a while later, about almost 10 years later, I got involved with patents. And that was because I worked with MySQL. Some also call it MySQL. It's an open source database. A lot of websites actually use it, or they use MariaDB, which is like the new name for what used to be MySQL. And that company faced some issues, especially with one very large company that at the time was not particularly open source friendly and threatened them. And then that was in 2004 when the EU was working on some patent legislation and a law that was about a topic that really has a lot to do also with this whole Nintendo Pocket Pair dispute, which is the extent to which you can patent software ideas, software-related ideas. So I've been involved with patents for about 20 years, and then the more recent thing, which is why I joined you last year, I think it was like a year and a half ago almost, to discuss the merger reviews, the global merger review situation surrounding Microsoft and Activision Blizzard. Technically, the litigation in the US, in fact, 2 parallel litigations, one by the Federal Trade Commission and one by class action lawyers, are still actually pending, but nothing's been happening lately. At some point, these things could come out of hibernation and something's going to happen. And we'll talk about that later. But I actually, tripled almost my follower base on X as a result of my commentary on that merger. And I guess the reason is because I took positions that were quite contrary to what most of the other people were saying, especially all the so-called experts quoted in mainstream media. But in the end, I was probably right on a higher percentage of those items and issues than a lot of others. Because I really believe that deal was in fact capable of getting cleared by the regulators despite some resistance. Now also, I knew it could take a while, but I expected it to happen. So now, where can people find me now? And where one way to find me, and that is where actually I have a larger, gamers network than on any other platform, is on X, the platform formerly known as Twitter. My name there is Florian for Gamers, 4 as a number. You can just search also like for my name, Florian Mueller, the way it is spelled here, then you'll probably find my account pretty quickly there. I started last December a couple of new websites, and the ones that are kind of like relevant here or that are related to the topics we're discussing are IPFray.com, IP meaning intellectual property, which is patents, trademarks, copyrights, and similar types of rights. IPFray.com, where I comment extensively on patent litigation and license deals and patent policy, and GamesFray.com, which is where I'm not that active at the moment, because primarily I'm like waiting for the Activision Blizzard thing to continue, because I think then I'm really going to need that website, and I will probably also get significant traffic when that trial takes place, FTC versus Microsoft and Activision Blizzard, and I will try to explain it on that website. So those are the two kinds of like websites, and my personal Twitter account, and hope that, yeah, maybe some people find the information today interesting. I plan to keep commenting on that whole Nintendo thing. I cannot promise that it's always going to be in great detail and it's always going to be rapid and frequent, but I certainly keep an eye on that one.
Fair enough. Well, that's awesome stuff, man. I mean, you mentioned that you did grow your user base extensively during the Xbox FTC litigation and all that kind of stuff. So where are we with that right now? Because it's not over, right? The FTC's still got a case pending. Like, what is the current situation on Xbox versus the FTC when it comes to ABK? Because most of us have just kind of moved on from that whole thing now and happily waiting for Black Ops 6 to drop on Game Pass next month or the month after. I can't remember off the top of my head. And it's when is that launch? That's October, right, Rand?
October 26th.
Yeah, Black Ops 6. So a lot of us have moved on from that court case, but it's still happening, right? So what's the current status of that whole thing, Florian?
Right. It's on hold at the FTC, on hold in the district court in Northern California, the Northern District of California, where some class action lawyers are suing. So the FTC went to Northern California last year when they were seeking that preliminary injunction, which they didn't get. And the class action lawyers were already there. So the class action lawyers, that means these are lawyers. They have gamers for their clients. I'm not doubting that those people are gamers. To what extent is another question, but they have filed some sworn declarations that they own certain consoles and PCs and what types of games they play. But in the end, that is the kind of thing where it's really the lawyers in the driver's seat, because the way that usually works, it would be a big surprise if it worked differently in that case, is that the lawyers look for those class representatives, as they are called. So they claim to speak. For now, they're not claiming to speak on behalf of all gamers, but that could happen further down the road. But they just need a few gamers so that they have an official client to bring a claim. And they are probably not going to go away until they lose and have exhausted all appeals, or Microsoft pays them to go away. The FTC is a little bit more difficult to predict, because there's an election coming up in the US in 6-7 weeks or so. You don't know what happens afterwards. It's really a mystery to me why the FTC keeps doing this. The only reason I can see, which is not a mystery, but still not enough not sufficient to justify this effort, is that they may try to move the goalposts with a view to future cases. So let's maybe quickly look at what were the last two important things that happened and what's going to be the next one and the one after the next. So the last year, the deal closed. That was in October. So what the FTC, however, is still doing is they are technically, formally, still appealing the decision made by Judge Corley in the Northern District of California last summer, where she said, sorry guys, FTC, you're not going to get an injunction. They wanted a preliminary injunction. If they had obtained that one, then Microsoft and Activision could not have closed the deal. After the FTC lost that injunction bid, the CMA in the UK, in fact, also then looked at this again, and very quickly they announced a settlement, like a new solution, a new deal structure, which meant that the UK was not going to stand in the way either. So they closed last October, almost a year by now. The FTC, however, kept appealing that loss. So that is something that for people who are not lawyers is probably a little bit hard to understand. Why would somebody keep suing over something that's like water under the bridge? Because even if the FTC won this appeal, and I don't think they will, but even if they did, there's nothing that you can do to actually prohibit something that happened in the past, short of time travel. So the problem is that they didn't have that injunction in place when they needed it, which was last October when Microsoft closed, and they just closed. It's now a done deal in that regard. But indirectly, legally, it could still have some ramifications. Totally hypothetically speaking, I'm really emphasizing this so that people don't kind of like panic. But I mean, totally hypothetically, the upshot could be after several years of litigation with additional appeals and all that goes with it, that Microsoft would be forced to divest all of ABK or parts of it. So, for example, everything except King.com or something.
Right.
But that is, again, very theoretical. Now, how does it help the FTC if it wins this appeal, which is about you were actually not allowed to close it last October? Because there's no penalty for Microsoft. It's not like Microsoft would instantly, like the appeals court would say, okay, but Microsoft closed and we think they shouldn't have, and that's why we're now going to, impose a fine or something. None of that's going to happen. All that's going to happen is like an academic type of like finding that actually the FTC was right last year, but Judge Corley did not understand that the FTC was right and Microsoft was wrong. That's this hypothetical scenario. The FTC would then, I believe, immediately run back to Judge Corley, would say, look, you were wrong last year, and now we have a new request. We now want to kind of like put some restrictions, impose some restrictions on Microsoft in terms of what they can do with Activision Blizzard. That would be like a so-called like a hold separate order, meaning that ABK would have to be run by management very separately. They could not further integrate, which is also a bit difficult because they've already done some integration. They've removed redundancies and everyone knows that, but they could try to get something like that. Now, what else could they do and will they do? What they're actually waiting for, the FTC. I mean, Microsoft's not really waiting for it because Microsoft wants the thing to go away, obviously, but the FTC is waiting for that appellate decision. The appeals court held that hearing on the 6th of December last year. It's been more than 9.5 months, or roughly 9.5 months since that, more than 9.5 months since that appellate hearing. It's highly unusual that it takes so long because generally that appeals court resolves its appeals. They get these appeals from all these West Coast federal courts, so California, all the way up to Seattle, down to San Diego. They normally resolve them, say, within 4, 5, 6 months. And this is a preliminary injunction appeal, which, if this was really about somebody running to a court urgently wanting an injunction, would have to be put on a fast track, meaning, suggesting that if anything, it should be faster than this. But this here is a crazy preliminary injunction appeal. It's like an outlier because they're seeking an injunction over something that has already happened anyways, and that cannot be undone by just winning the appeal. So that's why maybe the appeals court thinks it's not urgent. It could also be that they are struggling to somehow reach an agreement among the judges, or even forming a majority of 2 out of the 3 judges on something. And that's why after 9.5 months, they've decided other cases deserve to be decided sooner and can be decided sooner, and nothing's happened here. There is kind of like an order in place. The FTC has its own in-house court. So they have a judge who is an employee of the FTC, but he decides on cases that the FTC brings against companies. There are politicians who are profoundly concerned over this. They would think that may be unconstitutional, that could be challenged by someone at some point. I don't think Microsoft's going to bring the most aggressive challenges to that setup, but somebody else sooner or later will. And now they have this in-house court. The judge is kind of independent, but deciding on the cases brought by his bosses, basically. And now he said, well, we are really going to await and the FTC litigators. So you have to think of like the FTC being judge and lawyers at the same time. 2 roles, and that they say, okay, they all kind of like agreed that it makes sense to wait for what the Ninth Circuit says. Because if the Ninth Circuit said that Judge Corley was 100% right, and this is like a super pro-competitive merger, everything's great. I mean, that is what they could say. They could also say very little. It could also be that what they say is not really instructive, informative, or educational at all. It could just be that they could, just write a few pages and just, on some kind of like very simple and limited basis, just say, for that reason, it was okay to ban the merger and we have no problem with it, period. But normally it would be a decision of 20, 30, 40 more pages. And then depending on what's in there, it could be that the FTC is then going to make some slightly different arguments in court. It could be that the FTC would even say, well, we now actually accept that this here is like not winnable and we are going to focus on something else. And that's why they said, let's wait for the Ninth Circuit. Once the Ninth Circuit has spoken, it is on no strict timeline. I would assume that it's still going to happen this year because it really looks odd and almost, awkward if they don't put out something at least, before the end of the year, because then it would mean that they carry a 2023 matter over into 2025. And a year is really like where those types of appeals courts, if they haven't decided something after a year, that's where they really feel like we got to do something now. And that, so that's like psychologically a very, very, major barrier. So come December, if they haven't decided, then I think the likelihood is super high until the holiday season. It would be a huge surprise if that got carried over into 2025. But now, once that happens, whenever, it could be today, it could be while we are speaking, it could be that they're uploading it now as we speak. They don't announce it beforehand, they just do it. That at that point, the FTC's judge said, and the FTC's lawyers accepted, Microsoft and Activision's lawyers also have to live with this, that after that, at the earliest time for the trial, meaning, we have like a couple of weeks or so in court in front of this FTC judge, debating the whole FTC theory against the Microsoft-ABK merger. And you have to imagine, they will play the old testimony. They will play the videos that they recorded, the video depositions of people like, Jim Ryan, and all of that will come back. And after a long time, and even longer than the Dutch Corey's court, but at least 21 days after the Ninth Circuit decides. In practice, to just finish that part, in practice, it could easily take a lot longer. Because if the FTC, for example, decides today, 21 days, that's mid-October, and there are Microsoft lawyers involved. There are lawyers who were initially retained by Activision, which now belongs to Microsoft, but I think they're still kind of involved. And the problem is, they're busy. They're going to have some other trials in the meantime. So they're going to probably say sorry. And even the FTC's own lawyers may have other things to do, other court hearings and trials. So it's not even a given that they can really do it 21 days after the decision. It could also be that the next date they then find where actually everyone is available could still be a few months off.
Well, let me ask you this, right? We've got appeals going backwards and forwards and all this kind of stuff, but who's the authority that would decide, okay, Microsoft, you've got to divest this now? Is it just a random Ninth Court judge or Ninth Circuit Court judge or whatever? Or would it take something like the Department of Justice getting involved?
It's going to take more than one judge. So there will be, let's now assume that whenever, this trial happens, and it's increasingly likely that it will slip into 2025. Even if they rule today, it could slip. But if they rule, say, in 2 months or so, then it's almost certainly going to slip into 2025. After that trial of, 2 or 3 weeks or whatever, that FTC judge is going to issue a recommendation. It's just called a recommended decision. They kind of like downgraded the power of that judge because the people on top, even though he works for them in a way, but he still is kind of independent, they don't want him to be the actual decision maker. They wanted to make it very clear that he just makes a recommendation. Then it goes to Lina Khan and those people, meaning the commissioners, which are 5 people at the top, 3 Democrats, 2 Republicans. Normally, sometimes, they are like 1 or 2 short, but right now it's I think they are pretty complete. Now, the problem is, we don't know who at that time is actually going to be the commission because there's elections in the meantime, right? If Trump wins, then as soon as possible and as quickly as possible, he's going to make sure they have a Republican majority, and Lina Khan's not going to be. But let's assume it's still the Democrats, because they are the ones who are pushing this, and the Republicans are the ones who were skeptical as a party, because the Republicans are generally not so much pro antitrust enforcement and regulation, and like they're skeptical of anything that involves the federal government. If it can be avoided, it's better. Doesn't mean that they are against everything, but they are always skeptical. And Democrats are inclined to like this. So let's assume the Democrats are still in charge. And if they like the recommendation by this judge, they're just going to say, he's right, because we like it. If they do not like it, they have the power to simply do their own proceeding, which could take another year. And then they could even look at the evidence again. They could even also, hear witnesses again, all of that crap for like another year. then they make their decision, their determination, because they are the actual decision makers at the FTC. That one would be appealed by Microsoft if it's against Microsoft to an appeals court. It might go back to the Ninth Circuit because the Ninth Circuit's already familiar with it. It could be the DC Circuit in Washington, DC. And after that, it could theoretically go up to the Supreme Court.
But speaking realistically, you know, the deal's done. The companies are integrating. Is there even going to be an appetite to pursue this all the way up to the Supreme Court at that point, realistically, in your view?
I mean, let's look at it from the angle of what does the FTC
it just seems like a lot of money being spent on something that is pretty much done, right?
Well, the money is spent by Microsoft, right? And the FTC has these in-house people on its payroll anyways. But of course, they could do something more productive. They could do something more useful, that's more beneficial to the US economy, to US society, and maybe to all of mankind. But instead of, wasting time on this kind of like idiocy. But here's like how some of this legal stuff works. And that's where really, like, for this kind of like a regulator, they have cases all the time. And it's not even about the next games industry case that they have in mind. It's really like, could be any industry. Could be agricultural chemistry, whatever kind of like next case they have. They really want to move the goalposts for the standard in a way. And
so even if they got an academic win, they would see that as a win, even if it doesn't affect the Microsoft stuff.
Right, exactly. So I mean, if the Ninth Circuit, for example, even let me give you this scenario. Even if the Ninth Circuit came out with a decision now, anytime between now and most likely a year, and said, Judge Corley was right, but she was not 100% right. Here's something that she should have treated differently. She was right anyways on the outcome. It was okay to allow the merger to go forward, but the FTC was entitled to some, different standard here. Then it's like you have a mathematical problem. The result, the bottom line is the same, but you say you had an error in the derivation. And that would be a win for the FTC, because that different derivation, that different rule for the derivation could make all the difference next time around, right? It could make all the difference when they, for example, deal with an airline merger or something. And that's one thing. Now, the other thing is, let's assume they really see it through. It is really absurd, and that's what makes it so hard to imagine. But let's assume they actually see it through, like all the way to the Supreme Court, which would probably not be a good idea for them, given the Supreme Court being mostly Republican judges and all of this. But they have been somewhat friendly to antitrust enforcement against big tech in some cases, even some of the Republicans. And there could be the same thing, that they say, sorry guys, you do not. It's too late. You're not going to get Microsoft to divest ABK or COD or Activision or Activision Blizzard. You're not going to get that. They're going to keep COD. They're going to keep Diablo. They're going to keep everything. Even then, there could be something in that ruling, like one line. It could be a single sentence that they could then quote, that they could cite to in future cases. Now, of course, if that's where you want to get, then the argument is, why don't they just challenge every merger? And why don't they just do it all the time? Now, they have to set priorities. The question is this one a good, as lawyers would call it, a good vehicle for this purpose?
Right.
Apparently, they think so. Apparently, they think that there's something there about and in this case, and also what happened in Judge Corley's court when they lost. They somehow appear to think that they stand the chance of somehow moving the goalposts, still not scoring a goal, but you've moved the goalposts for next time. That's basically, I don't think they are as unrealistic as to really believe that they would, in the end, get Microsoft to divest ABK. I don't think that is what they seriously think. On the other hand, there's like a second kind of like political, legal type of benefit they get from still seeing this through, and or at least for the time being. It could always change. I mean, they might come to reason at some point. There might be different people, but is deterrence. They also want, you have to look at it this way. For the FTC, it's very frustrating. You saw what happened with Activision Blizzard, and some of our listeners probably followed, and maybe some are newer and or were not that interested last year. But you saw that the European Commission made a decision. They said, let the deal go through. Great for Microsoft. The European Commission had said no, the deal would probably have been dead in May of last year. The CMA said in April of last year, it's blocked. The stock price, the Activision stock price, like nosedived immediately. It immediately it plummeted, and a lot of the experts and everyone said, like, you're crazy, it's not going to go through. I kept like telling people there still is a pathway, there still is a possibility, but hardly anybody believed it. And the FTC is not in this situation. The FTC is not like those European regulators, which can really block you. The FTC depends on those US courts. It has to run to a court and ask the judge to block the deal for them. The European Commission doesn't do this. If you, as Microsoft or somebody who wants to do a deal, have an adverse decision from the European Commission or from the CMA, you have to run to the court, as Microsoft did in the UK. But they went to the Competition Appeal Tribunal. With the FTC, it's the other way around. And that's why the FTC is so heavily dependent on how the courts adjudicate these cases that it is very frustrating for them to also see that companies just close over. It's legal in the US. It's not that they could be fined for this. Even if the FTC won in the end, Microsoft would not be fined for having done this, because if the FTC doesn't get the injunction, you can close the deal. But it means for the FTC, they want companies to be more afraid. They don't want companies who do these deals, whatever the industry is, not about Microsoft specifically, not about tech. They want these companies to be afraid that the FTC might, keep coming after you for years and might, in the end, get the divestiture, and that would, give them more leverage, because what they often want, in this case, they were just against the deal. Khan apparently was just dead set to block the deal, but there are other cases where it's about negotiations, where it's about leverage, where it's really where they want to get those companies to make concessions, and then the more aggressive they are here, and the more persistent, maybe that means they make the better the deals may be that they make in other scenarios. So those are the two reasons: moving the goalposts and demonstrating persistence to deter and to have more leverage in other negotiations with parties, which would sometimes be Microsoft, but 99.9% of the time would be others.
All right. Well, that's a whole lot of information you just dropped on us for the ABK stuff. So I know time's a little limited on this one.
Yeah.
So let's transition to the thing that really made Jez pissed off. Florian. Jez he's not happy with Nintendo right now.
Oh my God, Rand's calling me out.
You aren't. Go listen to Xbox 2 on last week.
I was pretty mad. I was pretty mad.
You were calling Nintendo all sorts of names. So
I upset a lot of people, I think.
Yeah, just to set it up, and Florian will go in and explain all the nitty-gritty details that only he can do, because we're just couple schlubs, right? Trying to figure out what's going on.
Yeah.
Nintendo is suing Palworld and Pocket Pair, who I believe is the owner of
Yes,
Palworld.
That's correct.
In Japanese court over patents that Nintendo owns. So there's a lot that could go. A lot of questions that can go along with this. So I'll throw it over to you, Florian, to explain. Because Jez, you just mention how pissed off you were, and how you think this could be like the beginning of something very truly bad for the gaming industry. Yeah,
that is my perception. I could be completely wrong or off base on that. My perception was, every gaming company has tons of patents, but they're pretty much they're sort of like, I don't know, they
sit on them.
They sit on them, yeah. Like Microsoft has mountains of patents, and so sometimes they license them out, sometimes they just sit on them. I've been told, just in passing to some of my, sources and contacts, that sometimes they acquire sort of prohibitive patents just to stop someone else from patenting them, patenting them. That's a hard word to say. So, I suppose, Florian, if you want to give us, a high overview of this, because one thing I have been told, and maybe you can fill us in on whether or not this is true, is that the Japanese legal patent landscape is very different to how it is in the West. So, what are your high level thoughts on this whole situation? What's actually happening here?
Right. So first, I also don't like this. I don't like what Nintendo is doing, but let's maybe look at this now first in a non-judgmental way, just like totally in the abstract in terms of like,
Yeah.
how did this come into being and what has Nintendo been doing and why? And then we'll talk about whether it's a good thing and whether it could have negative effects, and also about differences here, potential differences between Japan and other jurisdictions. I would not want to overstate or overrate those differences, but there are some, yes. But it's not tremendous, because really there has been a fair amount of harmonization, of alignment of those different of the world's major patent jurisdictions and judges from all these places, US, Europe, Japan, etc. They and patent offices also, those people, they regularly meet and they try to really have a reasonable degree of consistency, but some things of course work differently in one place than another. You have jury trials in the US, and especially sometimes with billion-dollar verdicts, and in Europe you have all these prohibitive decisions, you have the injunctions, and then you have Japan, which is a little different. But if we now look at this from the perspective of just any games company, in this case it happens to be Nintendo with Pokemon, and you want to protect your intellectual property. You spend a lot of money. I mean, we know that some of these games cost even hundreds of millions a year to make. Like COD is like, I don't know, $500 million or so a year to just do the next version. There's a lot of money that goes into it, and even if the money is limited, Palworld obviously was not hundreds of millions; it made hundreds of millions, but on a low budget compared to a COD. You're looking for ways to protect it. Now, what do the world's legal systems offer you? If you want to just be protected from outright copying, so that people and that copying thing has already changed. I mean, copying used to be a big issue, when I was young and playing games like on Commodore computers, and also in the early days of the PC. But now that a lot of these games are actually services and they need kind of a subscription, copyright is not even as critical as simply controlling the server, and people need an account. But in the past, that was like all that like Blizzard at the time when I was there, we had seen somebody pirating Warcraft and just selling pirated copies. Didn't happen in my markets, but maybe it happened somewhere in the world. Then copyright would have been the obvious thing to use. So copyright protects also what Jazz writes and his colleagues write on Windows Central and the other websites you're involved with. It protects writers, it protects composers, it protects software developers. So software is then treated, like a writing in a way, and architects and some of those things. That, however, is really just outright copying. It has to be pretty much one-on-one. So copyright still helps you if somebody translates it to another language or something. For Pokemon, you would have a copyright violation if somebody really took the exact image of one of those monsters, or like, let's say, largely identical, materially the same, and copied that. And that's not what Pocket Pair did. They came up with their own monsters. They're just like a little Pokemon-like. But that's where copyright would have helped if they'd copied any of the program code. None of that happened. You've got trademark rights, and interestingly, Nintendo also, even when they announced that patent lawsuit, they still, at the end of that announcement on Thursday, warned everyone against infringing their trademark rights. Now, a trademark is really about the origin of the product. It's who makes it. So if like Pocket Pair had put like a Nintendo logo on it, and people would have thought, oh wow, Nintendo and Pokemon, and had sold Palworld that way, that would have been an outright trademark infringement. They didn't do any of that either. I mean, even further away than from any copyright infringement. Then, if you are now like Nintendo, and let's think of just any other games company that faces this, in a way you would like to have a monopoly in your field, or you would like, your ideas to be protected in a way that you don't have to compete with somebody who does something that maybe is just like, creatively built on your game concept. But here's the problem, and that's going to be a big theme throughout the probably multi-year dispute. Neither in Japan, nor in Europe, nor in the US are game rules patentable. Game rules are not copyrightable. So you can have a copyright on a book that explains game rules. You can write a book that explains how to play chess or how to play COD. And you will own the copyright on that book. But that does not mean that somebody else cannot actually use those rules, can describe them differently, put a new rule book out. If they write it independently, they are fine. Game rules are not copyrightable. Game rules are not patentable. And there's also no, what lawyers in Latin call sui generis, meaning like of its own kind, no special right for game rules. That's the thing. And I think, Jess, your concern is probably really about like, well, are we now going to see like patent warfare or lawfare in response to this, or like others saying, well, why don't we do the same? I mean, why don't we just get rid of this nasty, pesky competition? We don't want to compete. We just want to own this.
Well,
and that's what companies naturally do, right? But that's not where we have to look at how dangerous is it really, given that game rules are not patented.
I mean, it's interesting, right? Because there's this whole thing. This is sort of like slightly off topic, but there's this whole thing going on in YouTube right now, where a couple of big YouTubers did copyright claims on big YouTubers' content because they didn't like the criticism, and even though it constitutes fair use or whatever, that now like you're seeing a sort of avalanche of other content creators trying to abuse the copyright system. So I was wondering, like, if this whole thing with Nintendo and Palworld being like, okay, well, we're going to try and, whatever the patent is, I don't think we even know what specific patent they're trying to litigate against. But the assumption is that it's something related to using a ball to capture a creature into the Pokeball, basically. Because Palworld has
like throw a creature at another creature, and then you own the other creature, that type of thing.
Yeah. So I was just wondering, like, is this gonna? Because look, I used to browse patents for just to find things to write about, and so I think that's how we initially leaked the Surface Duo phone, because Microsoft published the patent. Patents are public, at least in America, and then someone found it on our team, and like, oh god, this is a phone, and then we wrote it up, and it was boom, exclusive. So like, I saw like I've seen Microsoft patent all sorts of weird things, and then never actually used them. So I was wondering, like, if Nintendo's going to start patenting something as basic as capturing a monster into a cage or a ball or something, couldn't this not lead to a sort of avalanche of other companies just being like, well, we're going to patent all our game mechanics as well. If Nintendo can do this, then we've got to protect ourselves. Like, how does this all work? And, if Nintendo, how likely is Nintendo going to be to succeed in Japan? And if they do succeed, how likely is this ruling going to be globally binding? Because one of the things we have seen is from the UK, being a comparatively small market to the US and China, who approved the ABK deal, they were able to do immense damage to the ABK deal, even though they're, the small country with a smaller market. So how does this sort of, how would this all sort of translate when it came to pass, or did come to pass, potentially?
Yeah, great. I mean, Jess, you've actually raised, like a host of questions, multiple questions in one, but that's okay. I mean, we'll go over them one by one, and we'll, have a bit of a dialogue. So I'll, try to like break it down into smaller parts, so that maybe also if anybody has a question, we can address it.
Speaking of that, someone just wanted to give you a shout out and said,
let's maybe first start with I'd like to start with this general question of, is there a risk of, this like changing other gaming companies' attitude? Would suddenly like Epic say, well, if anybody tries to compete with Fortnite, so we're like gonna sue, I don't know, some other Fortnite style kind of games? Would Tencent, which owns a piece of Epic but also has all these other franchises, would they start going after everyone? Would maybe Microsoft do it? Honestly, I mean, if anybody in gaming has a huge patent arsenal, it's Microsoft, because they're so big and they innovate in so many areas. So it would be quite difficult for anybody to sue them. I've personally been in courtrooms, I don't know, on hundreds of occasions in different countries for patent hearings and trials. I've read I don't know how many thousands of documents over this 20-year period, and I've also looked at a lot of patents like you have. Now, one of these things that people sometimes misunderstand when they look at these patent documents, and to answer also your part about public, they are usually public after 18 months after publication. So after filing. So if you file a patent application, then after 18 months it gets published. Whether it has been granted, usually it will not have been granted by the time. That typically takes longer. And then if it gets actually granted, of course, then it must be public, because that's the whole idea of patent. In fact, the very word patent comes from a Latin word, patere, which means to lay open, to be public. That's actually the origin of the word. And so the idea of the patent system, I mean, this now takes us back, but we're not going to do like a big history conversation, but not even far from where I live now, because over in Italy, like in Florence or so, I think is where some of these things were developed. And there were different parts of the world where it came up, but that was like one of them. They were thinking about, well, there were, for example, people, say they were pharmacists, and they came up with some great medications, like in the, not medieval ages, but, not much later than that. And the problem was, would they take those secrets with them to the grave? So the whole idea of a patent is, and that's why, the word also plays such a role. Also, by the way, I mean, in the UK, you had like letters patent by the Queen to, for example, authorize, I don't know, like, those privateers going and actually attacking enemy ships for looting them. The idea was, let's give people an incentive to make it public. So they get a time-limited monopoly, and that is also what the framers of the U.S. Constitution, there were letters like Jefferson and these people, and the whole idea there was that Congress, that is what I think the U.S. Constitution says, that Congress, for example, has this right to give people a time-limited monopoly. That is typically 20 years for patents. There are sometimes, extensions for pharma, et cetera, but it's typically 20 years in this space at least. And the idea is you get the benefit from your monopoly for 20 years, but you make it public, which means that for scientific purposes, people can study it upon publication. And after the 20 years, it's free for the taking by everyone. So that was the idea. And now, what does this mean for an industry? So I've seen these situations. So for example, you have industries that are notoriously litigious, and then and they will always be. So for example, pharma, they have a different situation than with Pokemon, because there it's really like they like research the same thing in parallel, and then they come out with medications that are kind of similar in parallel, even though nobody stole anything. The one who actually has the patents, the one who was first to file, has the right. That's the idea. So it sort of like incentivizes a race, not just to the patent office for filing, but also an innovation kind of race. You want to be first, because then winner takes all. Is that a good model for the games business, and especially like for these fundamental game mechanics? It obviously isn't, because if you patent those fundamental game mechanics, you would otherwise, reach a state of affairs where, for example, Microsoft could still make games, because they would go to Nintendo and say, okay, you want to stop all of these games, but we're going to shut down your entire console with our patents on everything. That patents on literally everything in the digital space. They can shut down everything from the controller over the console, over the software running on the console, to the servers, to the cloud, everything. Then you would need to have this mutually assured destruction situation so that you can operate at all. And that wouldn't make sense. And that is not the way it's going to work. And I think that I doubt that Nintendo is going to win, but they could win in Japan. It cannot be ruled out. If they did, we'll talk about that also then. I think it will be limited to Japan. But now let's maybe go back to, so what did Nintendo do earlier this year? They already were complaining about Palworld, and they did not mention even Pocket Pair Palworld. They put out this terse statement in the wintertime where they just said something like, yeah, we are going to protect our like Pokemon related. We are going to protect our franchise. It was very unspecific. Now they have carried out their kind of threat. It was a thinly veiled threat against Pocket Pair Palworld. Everyone knew it, and they have now actually shown that they meant this for real. What have they done in the meantime? That's something that also more and more of these articles discuss, and that more and more gamers find, like fascinating, and some even difficult to understand. Because in recent months, Nintendo has actually ensured that they obtained some patents specifically to attack Palworld. But I said before that the patent is for the first one who does it and the first one who files. And if something is out but was not patented, but it is public, for example, the game is, has been published and been downloaded millions of times, that also means that usually you cannot patent it. But there is something special here in the patent system. That is called divisionals. So the rumored patent family ensued, meaning the family of patents, the set of related patents that they are asserting here on this throw ball, capture character type of thing, was filed in 2021. And that's the so-called priority date. So if you want to say it was not new, or it does not deserve to be patented, you have to say, well, did it already exist before? If it was not the exact same thing that existed before, were there things that already existed that day, the priority date, and before, based on which this was not an invention? So, for example, if they filed something with a new priority date and Palworld has already put it out and millions of people have played it or so, they could not get it. But they go back, take this old stuff, or not that old, but from 2021, pre-Palworld stuff, and now they optimize it for litigation purposes. They sort of like groom these patents. They sort of like tailor them. It's like they just take this kind of original patent application and say, but there's like dozens of pages that describe all sorts of things, and on that basis, they now have actually obtained additional patents that really are designed to read specifically on Palworld. So that is just what the system allows. In all the major
that feels like really bad faith to me, that they can just create a patent to target a specific game they don't like.
Well, I'll give you an example from the US that a lot of people have heard about. I'm sure you have too. The Apple Watch case there, where the US ordered formally an import ban, and that's why they've they've disabled that pulse oximetry feature, right? Where they measure your pulse with the watch. That was the same thing. Those guys, the stuff was it was worse than the Nintendo thing. It was more than 10 years old when they saw the Apple Watch. And then after like waiting for like more than 10 years, within a matter of, I don't know, months or weeks maybe just, but in very short succession, right after the Apple Watch, they like went probably to an Apple store, bought one, looked at it, and then immediately filed some of these derivative patent applications where you built on something earlier filed, and then sued Apple over.
That's crazy.
That is actually what they did. I mean, like, let's go, let's do it, let's attack them. And that was, and in that case, I mean, the Apple Watch case is even more absurd and outrageous, but that's not our topic today. But that was part of one of the outrageous things they did. Now, so that's what Nintendo did, and you see others doing it as well. I see this in the wireless space when people sue each other over 5G patents. You see this. I mean, you look at when did they actually like make this last modification? When did they file this thing? You can often just tell based on the timing and how they do this. Now, what is it that you actually have to do when you do this so that you can then win? The name of the game is the claim. That is one of the most fundamental concepts of patent law, meaning the patent claim. So a lot of people look at these patent documents, like you said, Jess, you did. I'm not saying that you misunderstood them, but a lot of people, they do not look at the claim. So when somebody like me, who's been doing this for a long time, looks at this, I look at the headline that could, say like it's a smartphone or a gaming device or whatever, that gives me an idea of what it is, but you cannot sue over the headline. You cannot sue over the first paragraph that describes this. None of that is actually what matters most. What really matters is the claim. So a patent claim would be, and usually a patent has multiple claims, but then if it's one patent, then all the claims are kind of related. It would be grammatically, it's like a single term. So you cannot have like a whole paragraph with different sentences. It's more like a handheld computing device characterized by, and then it describes features, and it comes with, for example, or it's many of these patents are like method claims. So it could, for example, be a method for capturing a character in a video game by, in a three-dimensional environment, throwing a ball, a spherical object, whatever, and identifying a hit. That is the claim. And that is over what you actually sue. Now, the claim must be read against the background of the whole description. Because, for example, if it says network, then in one patent, network would mean the internet, in another one would mean a telecommunications network, and others might mean both. So you need to interpret it. You need to look at the whole thing, and then they can argue over this for years. I mean, they can argue for years over whether a network is a network or a network. But now what they did is, what Nintendo did is, they were actually trying to obtain claims that, as it's called in patent law lingo, read on Palworld, meaning that claims where they can argue that they are infringed by Palworld. But not only that, I tweeted about that, I posted about that today as well, because I saw there was another article coming out of Japan where a Japanese patent attorney tracking Nintendo's applications and looking at them now specifically in light of this dispute with Pocket Pair, made an observation. What he saw is that Nintendo is not just taking out patents and filing new patent claims, obtaining new patent claims that read on Palworld as it is today. They are building what I call, and what many people in the patent business call, a patent thicket. So Nintendo is now trying to obtain patents on things that Palworld is not even doing, but that they might do if they have to avoid the other patent. So they're trying to block all exits. That's what Nintendo is attempting. That's based on the observations of a Japanese patent. Right. And that takes me now to just, and then maybe it would be good if you also again tell me what we should focus on, and I will take the time as long as you find it's interesting to the audience. But let me very quickly, at a high level, say, if you are now Nintendo and you have filed your patents, they filed them in 2021. They obviously had no idea that one day Palworld would be the issue. So first you try to get this maximum scope of protection. And honestly, I think that all the major games companies are doing that, even the ones who are peaceful. I think probably Epic has never sued anyone over a patent, over anything, but I'm sure that even Epic, they patent what they can patent. They have the money. You have to put certain processes in place. You hire those people, and you.
Oh, and they've been working on that engine for decades. So they've got to have all sorts of patents relating to 3D rendering and stuff like that. They could probably skew a Nintendo one.
Exactly. And totally their stuff is more serious. But after you have this, what really makes you defeat someone like Pocket Pair? That's just what I'd like to explain in rough terms. So first, the question is your patent even valid? Because the fact that the patent office granted it does not mean that it's actually going to withstand a serious challenge. Because Palworld, these guys have a lot of money, and they're going to bring in great people, and they're going to try to prove that those patents that Nintendo has should never have been granted. And in fact, a very high percentage, in fact, in the fields I watch, it's a vast majority of all of these patents do not survive those challenges, at least not in the original form. They might get, curved, they might get, narrow, they might be less powerful. Then if they are valid, the question is, are they infringed? If they're infringed, the question is, well, that means that until, as long as you infringed, you owe them damages. And those could be substantial. I mean, if Nintendo argues that because they infringed those patents, they generate a ton of money with Palworld, we're talking about a sizable damages amount. It's not going to be $250,000 or something. It's going to be, probably tens of millions or whatever. But even that would not mean the end of Palworld, as we know it. It would just mean that they would have to look for a way to work around it. Can you work around? Can you just achieve the same effect? Or can you do something that gamers are going to like as much? So that instead of throwing a ball, they throw something slightly different. Or that the way that, it is detected, whether the ball hit the player, is done differently internally, that it looks the same to the gamer, but it no longer infringes. So under the law, it looks the same on the screen, but one is unlawful and the other one is lawful. Okay? And
wouldn't a ruling on that scale put Palworld out of business though? If they owed them tens of millions of dollars, Palworld's a small game, small dev.
My understanding is they've really made a huge amount of money. I don't want to toss out specific numbers because I've read different accounts, but that is something that I think if that happened, it would be a blow, and Nintendo would claim victory, and Nintendo would probably also use it, for this type of PR campaign to say they've stolen something from us. But and the funny thing is, they have not stolen what Nintendo made everyone believe they had stolen, which was like the Pokemon kind of trademark. None of that. What they are suing over is software. But talking about, I think they would survive. But the question is then, can they keep making Palworld? And you brought it up, Jace, also, because you said, well, you like the UK CMA situation with Activision, could maybe a Japanese ruling even have worldwide repercussions? So that's another set of questions. So let's just, to wrap this part up, let's assume they cannot work around, or they cannot work around this whole patent thicket. So maybe they can work around one patent, but once they go in another direction, they'll hit another, like a field of mines. They hit another Nintendo patent. If that was, wherever they go, left, right, center, whatever, they would hit a Nintendo patent, then it means they could not really, they would have to like change the game beyond recognition. That would have, commercial implications. Then the question would be whether that is an antitrust violation. Whether Nintendo is actually monopolizing a market through a patent thicket or even a single powerful patent. Even that is, there was a case involving printer toner cartridges in Japan, where the Tokyo District Court found Ricoh, that printer maker, actually in violation of antitrust law. Then they got acquitted on appeal, but at least there was a court ruling, and the appeals court also said, yes, theoretically there could be an issue, but it was not so bad, it was not an antitrust violation. They restricted competition. They wanted to get rid of these third-party cartridges, but what they did was still above board. So there could be antitrust issues involved at that point. I just wanted to say it. I mean, if it really reached that point, which I doubt, but if it reached the point where Palworld would have to essentially it's about forcing Palworld out of business, at least in Japan, that would raise serious issues. And then, of course, the question is, how could it impact other markets? There are two scenarios for this. Generally, a patent is a territorial right. So a Japanese patent is not a patent for a Japanese company for the world, but it is a patent for a company from anywhere. It could also be Microsoft or Sony or whatever, which is Japanese, or it could be a Korean company in Japan. And that means that generally, if they wanted to shut down Palworld, say in the US, they need to sue in the US over a US patent. They want to shut it down in Europe, they need to get a patent, say from the European Patent Office, or from a national office. So for example, in the UK, you have EPO patents, European patents that have a UK part. You also have patents that the UK IPO, Intellectual Property Office, grants. And if they had something like that, then they could force somebody out of the UK market. But they cannot go to the UK and say, I hold a Japanese patent, I'm wielding a Japanese patent.
Right.
Please stop Palworld in the UK. That wouldn't fly. And the Japanese court, there are sometimes what's called like long arm rules, or long arm statutes, so where court can say it cannot do it. The concern here is they might really try, if they won all the way and if they really went for maximum destruction and damage, they might try something where they would say that Pocket Pair is not allowed to export a patent infringing, a Palworld, a game that infringes on a Japanese patent or multiple Japanese patents, then allowed to export it. So that's a problem because Pocket Pair is in Japan. Then Pocket Pair would have to find, well, can we somehow avoid this by simply like moving all of the development and what we do, moving it out of Japan? And my understanding is that it's not that easy for a Japanese company to be bought by a foreign company for Palworld to just say, we just need somebody to buy us. We ask, I don't know, maybe Microsoft. I mean, then we have the next merger or somebody. That is theoretically, but I mean, somehow I'm sure there would be a way. I mean, the worst case scenario is that somebody buys them. There's also another thing, not likely at the moment to happen, but sometimes what happens is that companies, when they get attacked, they just on the market find some patents, they buy something to countersue them. And it could be elsewhere. So they could, for example, find some patent to shut down Nintendo in Europe or something, or at least have a threat, and then talk to Nintendo and say, look, guys, isn't it actually better we reach an agreement? And there could be an agreement. That is the other way. I mean, why did the CMA in the end make a worldwide impact? First, because they had the authority to block the merger. Microsoft would have run afoul of UK law. The only thing that Microsoft could have theoretically done if they had lost in the UK all the way, including appeals, would have been to leave the UK market so that they have no more assets there, that nothing that can be done against them there. And then there would have been no way to enforce any decision against them, but they would have had to give up the UK market, which they're not going to do. Here, it's more like if there is an agreement, if there is a deal, if at some point those companies sit down and say, okay, let's do this. So like Palworld paying Nintendo something and Nintendo just thinking that is like a face-saving exit from this, then of course you never know what they put in for other jurisdictions. There could be something that says on a global basis, you will do this, you will not do that. So theoretically, there are various ways where they could impact this. In practice, however, look at what I just described. There's a lot of hurdles that Nintendo has to actually get over in a row. The patent has to be valid. Patent has to be infringed. One or all of those patents have to be impossible to work around. That they have all exits are blocked, and then they have to. If that was the case, they'd have to get over an antitrust kind of defense. And if that happened, then Palworld might just have to move out of Japan. So that's and because if they only block it in Japan, I'm sure that for Sony, this whole thing must be quite frustrating, or because there is now this situation where apparently the Palworld community manager already hinted at a PlayStation version on Twitter.
Not only that, but Sony acquired the rights to build cartoons and movies based on Palworld.
Exactly, Sony Music, not Sony Interactive Entertainment, but obviously Sony as a corporation.
Yeah.
That's right. So they have that joint venture with them, and the third company, forgot which one it is. So there's going to be a PlayStation version. To me, it looks like they had a one-year exclusive deal, probably with Xbox. Considering that they're talking about it now, whatever it was, or I don't know, X number of months, maybe more than a year. But at any rate, I mean, they're gonna put out the PlayStation version for Xbox. Japan is not a major market. So if Nintendo only blocked Palworld in Japan, Palworld at worst case scenario, they just have to leave Japan. They have to sell themselves to a foreign company or whatever. Could solve that problem. Then like for Microsoft, really commercially doesn't matter because their markets are elsewhere, especially in the US and to some extent also UK, etc. But for Sony, it's a big issue. And which, by the way, raises another potential antitrust issue, which is, between Nintendo and Sony, whether at some point if they use a patent ticket and to against Sony, what would that mean? But Sony, of course, is pretty strong in Japan. But let's not make it too complicated. Let's know, what do we want to know? We want to know which patents they have. I think that the speculation that's come out of Japan looks like it's probably on the money. I think that those patents on those game mechanics are the ones, and we could talk a little bit about whether those patents really have teeth and whether they're really frightening or whether the weaknesses are.
If Pocket Pair lost, let's say the Japanese courts find that they did infringe on Nintendo and Pokemon's patents, could Palworld and assuming the patent's it's because you use the ball to capture whatever, right? Could an easy fix just be, and I don't even know if this is possible, but couldn't they just change the way you capture the monsters instead of a ball? Could it not be okay, we'll change it to a slingshot or something where then it's not infringing on the patent? Or is just losing the case, would that, it doesn't matter if you could change it, you've lost the case, so therefore you owe Nintendo whatever Nintendo feels like they should get?
Yeah, the second part is easy to answer. The second one is really easy. We must distinguish between the past and the future. So it's called retrospective remedies, meaning looking back, do they owe some damages? And for the future, does an injunction matter? Or does it not make a difference because you work around it? Now, the first part of what you raised is slightly more difficult because, yes, that is this big question of can you do a workaround? So to give you an example, even if it's a different jurisdiction, but in the US, Apple against Samsung about 11 years ago, 12 years ago, won a US import ban. The same kind of thing as that other company against the Apple Watch. Over 4 different patents. And those were 4 different features. Samsung's customers would not have noticed any important difference. Samsung just kept selling in the US market. They managed to abide by the injunction. They were totally in compliance, but it didn't really make a commercial difference. So that is the question then. Is it really going to be... Now, what you said, Rand, is interesting. Let's say they change from a ball to a slingshot. Now, at that point, it could be that Nintendo would argue, depending on exactly how it's done, and we don't know, we're totally speculative here, but we are speculating, but Nintendo could argue either that there is an injunction in place and that they effectively still violating the injunction because it is materially the same thing and the patent is supposed to cover it. The other thing is they could, try to take out another patent where they say, well, actually we like filed for a new one and now we're going to capture the slingshot scenario like they've recently groomed some. They could argue with what's called the doctrine of equivalence, which means that you say, well, you're still essentially doing the same, you're just achieving it in a slightly different way. But so the question is, are they far enough? It's not like a point, it's a range. It's like you are somewhat similar. You're still if you're very similar, you probably still have a problem, but at some point you are far enough away that you are fine. And that means if going forward, if for the future, then the only problem is they somehow have to deal with this financial hit, that they have to fork over a certain amount to Nintendo. But if it's really just Japan and all of this, then I don't know how much it would be. I mean, I said like tens of millions. I was assuming like a total doomsday scenario where the court would also do something extreme. Since it's only Japan and I think they could not easily get damages in Japan for the rest of the world, it shouldn't be that much. But the big question is, what do they do going forward? Yes. And then, but to get there, Nintendo now will face a lot of defenses. So there will be a lot of roadblocks in the way, and they have to move each and every one of those roadblocks out of the way to get to that point. We may have, and this is now an abstract parallel to what we discussed earlier on with the FTC and why they're still fighting ABK. It's not exactly the same because I think Nintendo believes that it can accomplish a lot more than anybody realistically believes the FTC can accomplish in the ABK case, in terms of like the likelihood of achieving something meaningful. For the FTC, it's an ultra long shot, and for Nintendo, it's very difficult. But that they get some kind of win is a lot more likely than that the FTC gets one. They may too just say, let's do this to really also for deterrence. We just want everyone to know that sometimes companies want to have this image, right? It's a bit of a conflicting goals issue because there are companies who want to be perceived as nice guys, and that's why they wouldn't sue proactively. They would only counter sue if somebody attacks them, or if somebody really does something bad, like an employee leaves the company and steals some of the code or something, then they would sue over this stuff. But usually they wouldn't. But then there are companies who actually like to have this image. They want to be perceived as absolutely, let's say, as someone who defends their rights, as someone who they want to deter people from doing this in the first place. And if Nintendo thinks, well, this is going to be a long one, this is going to take years, because if they won in the first round, the Palworld people would appeal. And unless at some point, people at Nintendo say, well, look, let's now look for a face-saving exit. Let's now settle and let's somehow claim victory on the basis of a settlement. But right now, it looks like it's going to last years. Right now, it looks like they want to have this fundamental question clarified, and they also want to deter everyone, because as long as the thing keeps going, even if it's 5 years, it means, of course, that some other companies are going to think very hard before they do anything that is kind of Pokemon-like, considering that Nintendo might actually start patent lawfare.
One of the things that I think me and Jez were a little cynical about when this was first announced was, and I know I'll just throw this at you, because when you said that Nintendo filed this patent in 2021 for the Pokemon stuff, do you find it interesting that that's when Palworld was actually announced in 2021? Do you
I'd have to look at the specific dates, because then you have to look. It could be that was before. I'm sure that Nintendo would just as a matter of the ordinary course of business, they would routinely seek to protect and obtain whatever protection they can. And that's why I doubt that it had anything to do with it, even if it had been shortly thereafter. I'm quite sure that they were going to do it anyways. They just looked at this as a major franchise, as a gold mine. But so far, no one has really, certainly no one outside of Japan, has ever succeeded in shutting down a major game. There has not been a dispute of this kind, of this, profile in the games industry so far. Anything that happened earlier on was really small compared to this. And now you have Nintendo, one of the best known players in the space, going against Palworld, like that overnight sensation and incredible newcomer success. There hasn't been anything like this. And I think the concern that Jess has is right. Obviously, there is a risk of an industry becoming more litigious over time. Like once somebody draws first blood, throws the first stone, and others will in the boardrooms where the decision makers are, and where we're going to say, well, do we really want all of this competition and all these other games that are kind of similar, not identical, but there are similarities? Shouldn't we do the same? Isn't that actually how we maximize our shareholder value? That there is that risk, and especially against small companies, because a company or new companies, young companies. So somebody like Palworld, that company, nobody knew of them really, or not, at least hardly anyone before this one came out, and they had no success of this scale before. They don't really have a patent arsenal themselves. So there are policy questions. It's like, is this a good thing? Do we want this? But then let's again remember that lawmakers everywhere in the world said game rules are not patentable. Now, I have to nuance this a little bit. There's lots of things that are not patentable. Game rules, mathematics, even computer software in places like Europe and in a certain way also in Japan is considered not patentable as such. So those two words, as such, mean, well, if it's only the game rule, it's clearly not patentable. You cannot have a patent on if you throw a ball at a character, hit the character, you've captured the character, that type of thing. That would be a game rule as such. But if it is the presence of a game rule or of a mathematical formula, I've seen lots of patents of mathematical formulas, sometimes no 2 pages, two lines long. The presence in a patent does not mean that the patent is invalid just because this is in there. It's not a mathematical formula or a game rule as such. There's something more. There's something else. It is embedded in something bigger, in something more important. That has to be a technological innovation. It has to be technical. So that is where they draw the line. Now, what does this mean? I try to explain it on the basis, without reading like the whole claim language, but on the basis of these rumored Nintendo patents, that the patents in suit, the ones that they are considered to be probably asserting now. And sooner or later it will come out. At some point, we're going to find out which ones. But it could take a while. Depends really on when, the Palworld people want to talk about it. And but if there's a judgment, we're going to see. The judgment is going to certainly list the patent. And if they hold a trial in Japan and it's an open court, then people who go there are also going to find out what the patents are. At some point, we will know. Let's assume that this Japanese expert is right, because it's very plausible what he says. The way those patent claims are architected is that you have a mix of game rule elements. So, for example, terms like captured character or like the game character, these types of game rule terms, you have them in there, but then they have all sorts of references to computer technology. So they talk about a gaming device, a game controller. They talk about like a virtual three-dimensional computer graphics space, that type of stuff. That does not mean that just the fact that they mention, for example, a game controller does not in and of itself solve the problem that it's a game rule patent. It would solve it, and I don't think it does, because I've looked at these patents. At least it would not anywhere outside of Japan, and even there it's going to be difficult, I think, for them to prevail, but only if there's something innovative. So to put it in, to phrase it differently, for people to understand, if the patent claim, which is like this quick wording, the short wording that explains what, like the scope of your monopoly, it's like you have a piece of real estate, and this is, like the boundaries of your property. If that, but in a verbal form, if that one was just a game rule, you throw a ball, hit the character, get the character, then it's a game rule as such. If they throw in things like game controller, well, then it's no longer a game rule as such, because they're talking about, collision detection, all of that. Now,
How it interacts with the hardware.
It would be what?
How the game rule interacts with hardware.
Exactly. And the thing is, if you, for example, if they said we like implement this game rule, and between the game rule and the hardware we put some really intelligent, innovative software that makes this work, then maybe that software would be patentable. So you would not own the game rule, but you would own the way to implement the game rule because you came up with something brilliant. You came up with something innovative. The problem I have when I look at this Nintendo stuff that is rumored to be their patents in suit is there really is nothing in there that is like, new, novel, innovative, inventive software technology. To explain this in a concept in very simple terms, in order for something to be patentable, a technical concept, a technical invention, for example, a software type of like technique, first, you must make sure that it didn't exist before. If the very same thing, more or less, like a photographic image, was already published in an academic paper, it was already on the internet, it was already in another patent application, that kills it. And the next question is, well, if it was not the exact same thing, are there maybe 2 or 3 things that you could combine? And then you get into these tricky questions over which you can litigate for many years, whether it made sense to combine them or whether nobody would have combined them anyways. But then the question is it inventive? Meaning, was there some kind of like, does not mean a total flash of genius. It's not like a patent is only for the most brilliant people. A patent is for the average kind of like innovator. But it has to be something that was not obvious that somebody else would have done it to. And that is where I struggle because they don't have a novel game controller here. They don't have a novel graphics kind of like system. They don't have a novel collision detection thing because you can be sure that before 2021, all sorts of games were capable of identifying the collision between a ball-like object and some other object. I mean, you had that on like Commodore Amiga in the 1980s already, basically. So, and if not even earlier. So that is my problem. There is no technological innovation. They just mention all these things like a game controller, but it's run-of-the-mill stuff. It's really like, and it's not even that the combination is new. I mean, you could have like, if you had this like crazy idea of attaching a game controller to an airplane cockpit, and then you have some software, and then like the pilot can do some job better, then I would say, yeah, I mean, it was really not intuitive to take a game controller into the airplane cockpit. But here it's about the game controller being attached to a gaming device. You have a screen, you have a 3-dimensional type of like graphics universe, and you do collision detection, and there's nothing there. It's not like they say we have a better collision detection mechanism. That, by the way, would be the kind of thing that maybe somebody like an Epic would patent. They would say, we have found a better means of identifying how these 2 objects collide. It takes less computing power. It's quicker, whatever. It saves resources. That would be patentable. That would be technical potentially. But what Nintendo does here is the whole innovation is in the game room. The whole innovation is that you use the game controller, you use collision detection, you use the screen, you use 3D graphics, none of which Nintendo invented, or none of which they invented now, especially after before in time for this. They didn't invent any of that, not even the combination. They only invented that you use this stuff for the purpose of saying, you hit the character, you own the character, and then you're at the game rule level. So the innovation is at the game rule level. That's the problem. And that's why I think these patents are going to get a rough ride in court. They're going to really be challenged very aggressively by the Palworld people. And if Nintendo loses those patents, then that is the end of the story. The moment the patent is invalid, it's over. Game over. And even if they were valid, then the Palworld people are still going to try to argue that what they did was a little different, but that may be the hardest part. So I agree with this Japanese expert who says that Nintendo really optimized those. They groomed these new patents for the purpose of saying they like laser-like. They really like pinpoint what Palworld does. So the validity part is going to be the harder one for Nintendo than that. But then the question is, well, would in the end the courts are going to have to interpret this. The courts are going to have to write long rulings explaining what these patents mean, what they are about, and those rulings in a way also then kind of like conversely explain to you what you need to do to work around them. Not because the court wants to explain it, but it's like the complement. It's like the mathematical complement. You know that from 6 to 10, the complement is 4. So if the court says this is what the patent covers and it's 6, then you just know, okay, if I'm anywhere in the area of the 4 to get up to 10, then I'm safe. So after the court ruling, then the Palworld people are going to look at, okay, can we work around this? And then the question could be, how can we just work around all of Japan because it's a crazy jurisdiction, maybe? But because if this kind of stuff succeeded in Japan, then I would say people would have to be really worried about Japan being an outlier, because I've really been to a lot of these patent trials. I've been watching over this extended period of time, well over a decade, cases in the US and in Europe. In the US and in Europe, where they don't even seem to have these patents. At least Google Patents does not display the equivalence of them, and Google Patents usually knows. If they tried that in the US or Europe, they would lose miserably. Nintendo would be pathetic.
Yeah.
They would really laugh them out of the courtroom. So in the US, what would happen is it would not even be put before a jury in all likelihood. It's like the judges would already throw it out. They would just say, look, there is really no actual innovation. I mean, at least the judges who hear patent cases all the time. So if you go like Texas and these places where they do it a lot, California, this stuff would die. And it would be a non-starter almost. And then if they did it in Europe, the European approach would be, I mean, I've seen these types of documents. So if they even try to get these patents, like the European Patent Office, if you file a game rule patent, for example, the European Patent Office, the same, by the way, like UK IPO, etc., it's like consistent across Europe. They look at this claim and then they see a term like game character. And you know what they do when they give you their feedback? They send you a version where they strike through all of that. So they just send you that version and they say, look, we've just actually eliminated all of the irrelevant part. You cannot patent the game character. You cannot patent the game rule. You have this thing. Now look at whatever little is left. And now tell us, why is this technically innovative? That's the way they would do it in Europe. That's also essentially the way the courts would analyze. I mean, they would not produce the document where they strike it through, but mentally they would do the same thing. They just shut it out. They just ignore this stuff like game character. That does not exist in patent law. That's not a technical concept. That means nothing. And this idea of you hit the ball, so you own the character, it would just be ignored. And then what is left? What's left is then collision detection. And they didn't invent that in 2021. So there is a residual risk, or there is some risk in Japan, because it was actually, there was this case where Capcom sued another company, a smaller one where the name starts with K, and they had a couple of patents of the kind where people say, well, they were also sort of like game rules, but they were not as bad as the Nintendo stuff, but they prevailed a few years ago on them. So one was about giving people a bonus if they inserted like a different CD or the same CD again into the same kind of like CD reader or something. Yeah, also, I mean, very kind of like shady in a way and debatable, controversial, but not as bad as this stuff. I mean, really, the Nintendo stuff, if one deals with this all the time, like I do, I mean, I'm not dealing with it, but I'm analyzing it all the time and writing about it and hearing people and the people who do these things. I mean, a lot of the world's patent judges, in fact, read my blog and all over the world, in fact. And so, I mean, I've seen a lot of this, and I can tell you, I read the Nintendo stuff. I can just say, I cannot identify, no matter how hard I try, I cannot identify this actual, genuine technological innovation. There is no innovation in there. The whole innovation is the game rule. It's crazy.
Yeah. I mean, it's weird the way this all unfolded. You know, when originally Palworld was announced and everyone was like, oh my god, sue them, they ripped off Pokemon. And then like everyone was like, no, you can't really patent, you can't really litigate over something as simplistic as a cartoon monster, otherwise everyone would be suing everyone over that kind of stuff. And now they fell back on this. It almost seems kind of desperate, almost. I've spoken to a lot of, you know, people who are more knowledgeable about this than me, including game developers and legal departments and publishers, and they just seem kind of bemused by the whole thing. But I mean, we've kept you long enough. It's 90 minutes in. I just wanted to, for you, Florian, there's been a couple of nice messages towards you in the chat from our community. One is from Nerds and Other Legends, says, I followed the ABK case and the only reason I understood any of it was because of Florian Mueller. Thank you for the guidance. And there's also been another one from Aloran Grogu, who says, no question from me, but Florian, I enjoyed following you through the ABK acquisition. You continue to be so informative, putting these complicated matters into terms we can understand. And I sure speak for me and Rand both when we agree.
Oh,
Thank you so
thank you
much
to
for
all
all
of
the
you. So then to the four of you, to these two people in the chat room, and to the two of you. And yeah, I mean, I've been doing this for a while. I used to write computer books when I was in high school still, so it was really about explaining technical concepts. And now what we have, patent law is basically a technical field of law. Patent attorneys are typically engineers with some additional legal training on top in most of these countries. So they're more engineers than they're actually lawyers. And antitrust is like the law of competition. It's economic concept and the law. And that's where it helps to then try to like explain this to people. And I like to do this. It's really been great to get all of this feedback. The specific one, this personal one here today, now I'm definitely going to read it in the chat room after this. But also, of course, all that I saw on social media, and what goes with it, of course, is the flip side of the coin is that you have the trolls, right? I mean, I've already had to block two people who, I don't know, for whatever reason, they hate Palworld, they love Nintendo, or both, or they just hate me, whatever the motivation was. But you know, just insulting on a totally outrageous basis, and making false claims about what this is about, and then on the basis of those false claims saying I got it wrong. And that's when I just have to like block these people, because you know, it's like life's too short to actually to read more stuff from them. But that's like the way it goes. And it looks like this is now like a patent dispute that really has sort of like an emotional element to it, where a lot of gamers, as they read about this, as they keep hearing about it, it can look kind of scary. One can also ridicule it, but with those other publishers and their legal departments, they may also have their reasons to take that stance. What I can say is it would be completely ridiculous in the US and Europe, which is where most patent litigation is. Japan only gets like 150 cases a year. So a country like Germany alone gets a lot more than that. Germany alone gets hundreds. I mean, there are single courts in Germany that get more than all of Japan. And in the US, you have like thousands of patent lawsuits a year. But in Japan, some of that stuff may get a little bit further. That it may be a little bit more of a risk to the Palworld company. That's what one has to be realistic about. But it's not like the sky is falling on them. But there will be all sorts of news. And it will be like with ABK, when people heard like the CMA blocked the deal. What does this mean? Does this really mean the deal is dead? Well, the stock market certainly thought it was next to dead. It was on life support. A lot of so-called experts thought it was on life support. And that could happen here as well, because if they hear the Tokyo District Court has ordered an injunction, has banned Palworld, then people are going to panic. They're going to think, oh, that means that now all over the world, Palworld's going to disappear. It's not going to be anywhere. And then one actually has to look at this. Everyone has to see, okay, I mean, first, can they appeal? Will it be stayed during the appeal? Some of the concepts we had in the ABK context already last year. But then there will be patent law specific concepts like working around and these types of things. All of that will happen if this thing doesn't settle. And for Nintendo, desperate, I mean, I would say they're certainly belligerent, and they're desperate in the sense that they probably just like hated the fact that this little company came up, did something that others thought they should have done, that they should have made more out of Pokemon. But let's face it, I want to like nuance it just to this extent. I disagree with Nintendo. I consider these patents unpatentable. I think this stuff should never have been granted in the first place. They shouldn't even have filed them. That's my personal opinion. But I have a little bit of an understanding. I can understand this desire that a games company, like any other company, would try to monopolize this. And frankly, a lot of these companies have done it. And a lot of these companies, some of them just want to get paid for their patents. But Nintendo doesn't sound like they just want to get paid, because they said, we want an injunction and we want past damages. They did not just say, we made Palworld, we made Pocket Pair an offer. We just want 2%, and they pay us the 2%, which would also be outrageous given that these patents are so ridiculous. But if that was the situation, it would be a lot easier. And then the question is, okay, so they didn't pay the 2%. But this looks really like they want people to be kind of scared. It could be a cultural thing. I've seen so many other companies, and also the way they make these announcements, they are different.
Yeah, it's going to be really interesting to see how it unfolds. I guess. I mean, a lot of people think it won't amount to anything, but there's a lot of Nintendo fans that were rooting for something to happen, you know. But yeah, we've been here for 90 minutes, so I'm gonna let you go
Totally great,
now.
yes.
Yeah, dude, I feel like I could become a lawyer myself now. I've learned so much, but or maybe not.
Yeah, you
But,
just need those games companies. You just need those games companies to pull the trigger on all of these legal proceedings. If Sony had not challenged the ABK deal, then chances are that the regulators would just have waved it through. But Sony did it, and that gave you and a lot of people the opportunity as gamers to then learn about antitrust law.
that
And
is true.
in the end, I mean, gamers were starting to talk on social media about theories of harm, about a substantial lessening of competition, about partial foreclosure versus
Yeah.
total foreclosure.
It was wild. Like we've covered that stuff so much. Everyone learned a little bit about competition law. Like I had no idea how. I didn't even know the CMA existed in the UK before all this shit went down. Like, it's crazy how much you sort of learn in a short space of time. And like some of our community members said, you were really kind of a rock star in sort of bringing everyone along for the ride. So thank you so much for that on behalf
Yeah,
of the
well, I mean,
community.
this is now going to happen with patent law. So if this Nintendo thing happens, and especially if some kind of like seemingly at least spectacular things happen, then you're going to find a lot of gamers who are going to talk about patent claims. They're going to talk about prior art, which is, the older inventions where you invalidate. They're going to talk about inventive step. They're going to talk about patentability rules. They're going to talk about workarounds. You're gonna see some of that maybe. I mean, if that thing reaches that ABK-like scale, then people are going to start to use that patent law lingo that most of them wouldn't know today. And they're also going to learn about institutions they didn't know existed. Let's see. Just one last thing about what could happen there. I doubt it, but there is, of course, the possibility, and someone's already mentioned it also in some of those media reports, that Nintendo will try to find some patents they can assert in other countries. So it could be that at some point they escalate. That there could be something where at some point we hear they've now sued also in Europe or something over different things. So that's why I said, I mean, this thing could escalate. It could also at some point be that people look at it and say it was much ado about nothing. We don't know yet. In the end, ABK was much ado about nothing because in the end the deal got cleared anyways, and Sony just delayed it. But until we got there was more than nothing. So thanks to the two of you. I mean, it's been totally great that we had this opportunity to discuss it. That you asked, that you brought up these questions that apparently were the ones that the audience would also have wanted to ask. And now let's just see. And if something really big happens, like they get an injunction and talk about like Palworld being illegal or something, then we'll reconnect and analyze it together.
Awesome. Well, thank you so much, dude. Where can people find you on the internet as we're getting out and closing out here?
In the beginning, but doesn't hurt to mention it again. So it's Florian for gamers, 4 as a number, all in one, of course, as an X Twitter handle. And they can. That's my personal account. The one also, for also sometimes comment on the ABK stuff. And that's basically where they should look now. And I'm going to stay around. And they certainly know how to find you. They have found you. That's why they're here watching your podcast. And I'm sure you're going to, from time to time, write about it as well. So
Yeah,
it's going to be, let's see, hopefully it's going to be entertaining. And there will be other things at some point. Maybe at some point, everyone's just going to say, okay, finally the FTC has actually closed the book on this and it's game over for the ABK merger case, and that is over. I'd like to see that happen, but we'll see what happens in 2025. We might still be, in a year from now, some of that stuff might still be ongoing.
Interesting. Well, thank you very much. And, Rand, do you have any closing thoughts?
No, I mean, Florian pretty much answered everything I was thinking about, or the things I could think about. So, I don't know. I think we said it on the show last week, but to me, I mean, I get companies need to protect their intellectual property and stuff like that, but Nintendo kind of comes across as like a big bully in this sense, in a way.
Yeah, I think so.
And I don't know. It's and partially I think Jazz is because we have no love for Pokemon. It's just
I used to, but they got lazy, man. They just got
I don't
lazy.
know. It's
it broke my nostalgia when they started doing that.
My hope is that Nintendo loses, for
Same.
for the reasons, and then this doesn't become like a bigger thing that you start seeing other patent holders, like starting to maybe eye up, a quick way to make some money. Because I'm sure Nintendo's looking at it like, well, hey, Palworld's made a lot of money, and Palworld can be a competitor in the future, and Palworld's got like all this stuff, and maybe we can kind of take some of it now. Like, I would hate to see that line of thinking and all that stuff kind of like enter into the gaming sphere if they indeed won, and then all of a sudden, like every year you have like a big company trying to bully a smaller one because they infringed on some patents. So, well, it'd be interesting to see how this all plays out. But thank you, Florian, for coming on. I like Jez was like, man, he DM me, he's like, yeah, this is so interesting. I'm like, yeah, I know. Like, I'm sitting here just like listening to Florian, like, and I was like trying to think of questions to ask, but he went into every single angle and stuff. So I was just like, yeah, I feel like I know my stuff now. So thank you.
Oh yeah, well, you're welcome, and I have to thank you. And definitely, I mean, there will be new angles as this unfolds. There will be some new things, but for now, I think, I mean, we don't know yet for sure what these patents are. There's just like some plausible assumption here, and a lot of this is unclear. But I just wanted to basically agree with Rand's concern over like Nintendo coming across as a bully. That was also my initial reaction. In fact, I replied on Twitter to the Palworld _EN account with that word. Bully was actually in there, Rand. So I actually said that if it's really is about these kind of like software patents, then this is just an older and bigger company bullying a younger and smaller one because they have a patent arsenal. But then Nintendo itself gets sued all the time. There have been tens of millions of dollars that they were, the U.S. juries ordered them to pay in cases. They've had problems in Europe. They've been sued all the time themselves. And we were not going to talk about it now because we're done, but let's just say I'm sure that not everyone inside of Nintendo is happy with and was in favor of this. There must have been and still be people who thought it was a bad idea because the reputational impact that Rand brought up now is not actually worth. The reputational impact makes it like a losing proposition that even if they won, it would not be worth it. So Rand, your point is well taken.
Yeah, for sure. Well,
great.
That's
Fine.
This week's Xbox 2+1. Thanks to everyone in the chat for joining us, and thanks to everyone who's going to be listening later on podcast services and on this YouTube channel as well. So Florian's links are all in the description, so you can check out his content. Obviously, Florian is a major expert in the field and has educated so many of us on all this stuff. Really appreciate him and everything there. So thanks, everyone. We'll see you on Friday for the next show, and keep it gaming.
Later.